J'invite maintenant Otachi à venir le trouver à la tribune. Je vais faire la présentation de Otachi. C'est un avocat de la défense au TPIR et aussi à la Cour pénale internationale. C'est un avocat de la défense dans l'affaire Kenya 2 devant la Cour pénale internationale. Ancien conseiller juridique de l'Association des avocats de la défense du TPIR, membre de la société Law Society of Kenya, avocat auprès de la Supreme Court of Kenya, un collègue estimé et un bon ami. Bienvenue.
Merci. Bonjour collègues, bonjour confrères, bonjour amis, bonjour tout le monde. Je vous salue en français parce que je reconnais que je suis dans un territoire francophone ou un territoire de francophones. Mais sinon, je m'exprimerai en anglais parce que je suis en principe anglophone. Thank you very much, Mr. Tremblay. While on the issue of Anglophone versus Francophone, yesterday when I introduced myself to someone as being Anglophone, I was corrected by my friend and colleague, Mr. Philpott, who said I'm actually Swahiliphone. And Swahili is the language of the East Africans, but of course, because of the colonial history, we basically have French and English as the main languages. Now, I must start by saying I'm very happy and, should I say, privileged to be in the company of esteemed colleagues, jurists, academicians, politicians. I don't know where to place my friend Ford. Maybe as a politician as well. But I'm very happy to be amongst you all to share a little bit of what I know or I have experienced. And I'm happy also to be in this territory of Quebec for the first time in my life. And of course to be in the company of my colleague Mr. Tremblay alongside other Canadian lawyers we worked with at the ICTR for a long time. Now, I will start with an apology, which is two-pronged. I do not have a written paper, and you'll excuse me for that. But again, because we have a very short time, even if I had a written paper, it will not really make much difference. But ultimately, I may put these thoughts that I have today on paper and distribute by email later on. And another aspect of the apology is related to the first one. And I tender the apologies of Mr. Kennedy Ogeto. Mr. Kennedy Ogeto is the one who was slated to address you on this subject today. He's my colleague. He was not able to travel due to professional and family reasons. And for that reason, we agreed that I'll present the thoughts on his behalf. But what I will speak is what he would have told you, because we more or less behave like twins. Now, I've been asked to speak on the Kenyan case at the ICC. As most of you know, the Kenyan case at the ICC arose out of the results of the chaos that followed the elections in Kenya in 2007. So to that extent, one would say that the objective of the Kenyan cases at the ICC is to, in a way, seek a resolution to a political problem, a problem of choice of leaders. Now, very briefly, we had two major protagonists in the 2007 elections. One party was PNU, another party was ODM. Now, this may not be very important because if you try and follow Kenyan politics, you'll get lost because every other day there's a new party. In fact, at the next elections next year, the PNU and ODM may not feature as prominently as they did last time. But having said that, after the ODM lost to the PNU, and now PNU was led by the current president, Mwai Kibaki, and ODM was led by the current Prime Minister, Raila Odinga. So after ODM lost, there was discontent, and there were demonstrations which spilled over into chaos and killings and so on and so forth. And there was some sort of fighting both ways. And that's what ultimately led to these proceedings. And another important aspect of these proceedings, the Kenyan case at the ICC, an important aspect is that this is a very first scenario where the ICC has instituted proceedings suo motu, that is, on its own motion, upon request by the prosecutor. I do know there's someone who's going to speak on the procedure at the ICC later on today, but just to place this in context, there are three scenarios that obtain at the ICC. One is a scenario where there is a referral by a state that is a member state of the ICC, and that is the case we have with Uganda, DRC, and Central African Republic. Then there is a scenario where the Security Council makes a referral, like in the case of Sudan and Libya. Now, the Kenyan case so far has been the only case where the ICC commenced proceedings on its own motion. Now, why is this important? It's important because in determining that the ICC should intervene, there was the issue of applying a judicial test. In the case of a self-referral, a state decides, well, we want this kind of situation referred to the ICC. So the ICC does not play its role, it accepts a referral, just like in the case of the Security Council. Now, so because of this unique scenario of applying a judicial test to determine whether the chamber, there's a pretorial chamber that determines whether the ICC should be seized of a particular situation, there are important issues of the threshold, the gravity of the scenario, and the jurisdiction. All these are interrelated. The court must determine whether it should go in or not and set out the parameters. Now, in this regard, I want to share with you what I think is particularly important, not just with regard to the Kenyan case, but with regard to the future of the ICC and in determining how and when the ICC should intervene in a particular scenario. Now, in its decision of 31st March 2010, there was an important dissenting opinion by Judge Kaul, Hans Paul Kaul, dissented in the decision to allow investigations to commence. And the gist of his dissent was really that he did not feel that the Kenyan case was serious enough. The Kenyan case satisfied the parameters of jurisdiction. And I say this is important because as we go forward, tens of years to come, this issue is going to be revisited over and over when the ICC tries to intervene in a particular scenario. Now, the ICC was interpreting Article 15 of the Rome Statute. I certainly do not want to bore you with the articles and of the statute and so on and so forth, because a lot of anything you read about the ICC is punctuated by article this, rule that, and so on. But I'll try to be simple.